proper medical attention is availed, even if under police escort. Further on, that he was attended to at the first instance at Kijabe Mission Hospital, so that the defense suggests a period of 3 to 4 days for such medical attention. The prosecution has opposed this submission, stating that the respondent is represented and hence not personally responding to this application before court, but through counsel. That the application be heard and thereafter the court may make an order that the respondent be taken to hospital. I have considered all these submissions, and yes, it is true that the respondent is injured on the upper left shoulder and there is a visible bandage on the same, as the court can see. Articles 20, 21, and 22 of the Constitution have been relied on heavily by the defense in their submissions. There's also Article 28 that has been mentioned on the aspect of human dignity. The Court of Appeal in Criminal Appeal Number, I will give this to the prosecution and defense. Please take one each. That's the authority. The Court of Appeal in Criminal Appeal Number 50 of 2008, Julius Kamau Mbogwa versus the Republic, held that the breach of a right to personal liberty of a suspect by police per se is merely breach of a civil right, though constitutional in nature, which is beyond the statutory duty of a criminal court and can be expressly compensated by damages. Looking at paragraph 10 of the supporting affidavit to this application, and I hope we can all see that paragraph 10, it has been referred to by both the defense and the prosecution that there indeed is a wound on the left upper shoulder of the respondent. This wound is a subject, this wound is a subject of part of the investigations that are sought to be carried out. I will quote paragraph 10 of that supporting affidavit of the investigating officer. It says that the respondent was found with injuries inflicted on the left chest area, and these injuries are suspected to have been occasioned by a struggle with the deceased person during the incident. And it goes on. So without disregarding the seriousness of the subject wound, this court makes a finding to the effect that the application hearing proceeds for hearing, so that as a matter of priority, the court may give directions on the way forward with regard to the application in its entirety, and more so on the aspect of the respondent being availed immediate medical attention. So counsels and prosecution, I'd like us to proceed with this application so that then I may give directions on that subject, which, as the court has explained, is serious in its nature. Medical attention, urgent medical attention. Can we then move forward? Do we have the investigating officer?
Yes, Your Honor, present. I swear that much work that the evidence shall give before this court touching the matters in question shall be the truth, the whole truth, nothing but the truth, so help me God. Your Honor,
I need to see the investigating officer. Yes. Yes.
Because this is an application that has been presented. And the understanding I have is that for this application to be, there's only parties to argue, not the deponent saying that we have to take off again, because we are already an affidavit which is under oath, so that to serve as first time, we proceed with the prosecutor making the submissions, because when he takes off, it means then that we have to cross-examine him and prolong the process, so that we can continue ourselves to the issues that are being brought here. Because the risk is, if we proceed, then we are going to put questions to you, which are going to be covered and above what has been stated.
Mr. Leitchen?
Yes, that is the actual issue. Because actually the application
is straightforward. I think the prosecution can go ahead and prosecute. I mean, and like the same respond.
The same sentiments, you know, that there have been affidavits was been filed by one IP Maswelatieno, which is comprehensive, and I don't think there's any need for him to testify.
Prosecution, you should respond. The other will only highlight on crucial issues.
Yes.
And if defense can examine him, and then I will respond.
Can I give directions on the way forward?
Yes.
Will just take oath for purposes of propriety and clarity of record. Just sum up his affidavit so that the defense may respond, and the prosecution counsel will close those submissions. So let him just do it so that this is stated under oath, because some of the matters that have been stated in the affidavit, I'll say all of it, is very weighty. So let him just sum up his affidavit. You respond to what he would have said, and then the prosecution counsel can sum up everything else.
Is it understanding that we shall, in the summing up, give questions to him?
Well, the three of you have said this is a straightforward application. This is just a practice with the court that he needs to do that. You sum up. If you feel that you need to cross-examine, so be it, you're at liberty, because then he has taken oath. That's fine? Okay. Please take oath again.
I swear by the mighty God that the evidence that will give before this court touching the present question shall be the truth, nothing but the truth, so help me God. Your Honor, I'm number 236-730, Inspector Maxwell Otieno. I'm working at the DCI Reporters Homicide Section. And one of the investigating officers in this matter. Your Honor, we are investigating a case of murder of one Monica Nyawira Kimani, which occurred on the 19th of September this year, but became known on the 20th at the residence of the deceased person. This is at Lamoria Gardens apartment, house number 8. Your Honor, we took over investigation of this case yesterday from DCI Langata. And the reason why I'm before you is that we, the investigating team, are seeking for permission from the court to be allowed to detain the suspect in police custody, bearing in mind that he was arrested yesterday, the 25th of September, by DCI Kilimani. We still have a long way to go in our investigations. Part of what we want to establish is about the wound that has been extensively addressed to you by the council, so that it may be known whether it's a gunshot wound or is a wound that was inflicted by any other weapon. I'm saying that because preliminary, it is suspected the same may turn out not to be a gunshot wound at the end of the investigations. Your Honor, I also want to address the court still on the hooks that the accused person is on medication.
For now,
We also need to question and read the statement of several witnesses, some of who are well known to the suspect, and it's my fear that if this is done while he is out of custody, interference may occur with the witnesses. Thirdly, Your Honor, we need to subject the suspect to the normal police procedures. These will include conducting of ID parades and we also need samples from him, DNA samples which we will wish to subject to for further investigations in relation to exhibits that will be recovered from the scene. And having taken over investigation yesterday, it is paramount that we revisit the crime scene with a view of collecting more evidence. I have also indicated in the affidavit, Your Honor, that the deceased met her death, immediately upon her arrival from South Sudan. We will wish to extend our investigation to South Sudan just to interview witnesses from that area. We are also interested in IC3, that is the data that captures the movement of the suspect while using the vehicle, and preliminary, it has been established that the suspect was through IC3, which we need to explore, and the mobile data from his mobile phone. So without, due to the facts that I've stated in court, I do request that for purposes of justice, both to the deceased and the suspect himself, the court do allow us time to conclude our investigation, so that at the end of the investigation, if we do not find anything connecting the accused, we shall be happy to set him free. But in the event that we'll find evidence linking him to the murder, then due process will follow. That's all. That's all.
All right. Now, I'd like the defense to read the situation.
Your Honor, Jacinta Nyamosis, yes, I wish to come on record for the prosecution. We'll be acting together with Ms. Levy. We have, as the IO has said in his affidavit, we do wish to have the suspect placed in custody. And the facts that have been deponed to by the IO, both in the supporting affidavit and in person are compelling. There is good information and it's cogent.
Na mtazamaji, ni kesi ambayo inaendelea katika mahakama ya Kiambu, ambapo muda wote kutoka sasa tutakuwa tunapata uamuzi kutoka kwa hakimu mwandamizi Stella Tambo, ambapo baada ya kupeana nafasi kwa sasa hivi ni Michael Oyamo, ambapo ni mshukiwa vilevile wa mauaji ya Sharon Otieno upande wa pili katika mahakama ya Milimani, ambapo kesi hii imesikizwa na tunatarajia kwamba uamuzi utakuwa unatolewa mwezi ujao kuhusiana